key here is, do we need new tools, or are the tools that we have sufficient? And before I start, let me say, I'm not here as a Google guy. I do work for Google, and of course, my opinions will be shaped by the fact that I've been there for 8 years and I've advocated for the company's positions, but the opinions expressed today are my own, rather than an official company position, for example. So there are a couple of arguments that are abroad right now about why intermediaries need to do more. I would classify them into two sections. One of them is the argument from need, we might represent it as. And the argument from need suggests that, I'm sorry? Oh, no. In fact, I have very few slides, so hopefully I'll be entertaining enough just by speaking that I will keep you with me in this, the perilous pre-lunch slot. So there are two arguments. One is the argument from need, which is to say that harms are ever increasing online. There are some big players with the capacity to do something, so something must be done. Now, a version of this might be seen in actual law to do with intellectual property, where in the EU, injunctions can be placed on ISPs by the court, requiring them to block access to certain sites to prevent potential copyright infringement. The other argument is an argument from size, I would characterize it as. And there are two subversions of this. One subversion is the gatekeeper argument. The gatekeeper argument argues that you have become so critical to a certain sort of access that you also have greater responsibilities, that you must be asked to do something to prevent harms. The other, which is rising but less typical, is the argument that you have too great size, and it means that you distort markets, you have too great leverage in negotiation with other industries, and so on. I think all of these are very interesting. I'm particularly interested in the gatekeeper question, but what I'm going to talk about today is the argument from need, the argument that there are increasing harms that we need to deal with, and we should just address whatever players are capable of dealing with it, namely internet service providers. So there are three things I'm going to say today. One is that I will posit that there's been a change in political rhetoric around internet society services, or OSPs, or intermediaries, in the last roughly 5 years. Two, I'm going to ask whether that change is a result of actual increase in harms. And then three, I'm going to propose some things that we ought to keep in mind as we try to remedy the harms and address the internet service providers. So the one thing I want to say, the first thing is that the tone in the debate has changed. It's become more contentious, and there are a lot of things in the news that affect this, of course. Privacy, competition, all of these issues matter. But I want to point to the language of the Commission's 2010 consultation on the e-commerce directive, in which they write, the e-commerce directive aims to remove barriers to the establishment of providers of ISSs and to the cross-border provision of online services, therefore giving both businesses and citizens legal certainty, which I think is interesting. It's very much create a market. It takes for granted the fact that these services are beneficial to society and to business. And this isn't cherry-picked. If you reread the document, which is public, this is roughly the tone of the entire document. Now, respondents to the 2010 consultation roughly fell into three categories. You had the online intermediaries who spoke a lot about facing high compliance costs and legal uncertainty. They spoke a lot about the fragmentation of intermediary liability law across Europe and the difficulties that caused. You have rights owners and interest groups around certain harms, child safety advocates and others who argue that illegal content stays online and stays accessible too long. And this might be due to insufficiently clear rules and easily identifiable procedures. And then the third group argued that fundamental rights were not always respected online. These are freedom of speech advocates and so on. who want to make sure that we are not overly censorious in whatever new rules we come up with. In 2012, you then have the notice and action consultation run by the Commission, narrower in scope than the e-commerce directive consultation, looking merely to see whether the Commission ought to codify what intermediaries should do, what the process should be to remove harmful or right-infringing or illegal content online. Now, in the meantime, as this is happening at the Brussels level, nationally, there's a lot of clamor and rancor going on. These are only examples from the UK, but there are many others. In the UK, David Cameron, the Prime Minister, in the last several years, has pledged to deal with revenge pornography, the practice of putting up intimate pictures of one's ex-partner or lover in revenge, anti-terror on the internet, and in child safety. Children should not have access to bad things online. I think it's noteworthy in all of these that the only legislation that's been passed along these lines has been for revenge porn, and that specifically criminalizes the distribution of the material in question rather than targeting the intermediaries. But we can see that, that there's a lot of conversation going on about this. Just to give you a couple of examples, outside of the UK, in Italy, the communications regulator was given special powers to enforce against copyright infringement. And in France, in the wake of the Charlie Hebdo killings, the anti-terrorism law included search engine provisions, requiring search engines in response to requests from law enforcement to remove within 48 hours pro-terrorist and, strangely perhaps, child sexual abuse imagery online. Now, I say strangely because we understand in response to a spike, to an incredible event like the Charlie Hebdo killings, why the anti-terror provisions might be included, but CSAI, as it's called by people who work on this issue, seems independent of this. In addition, child sexual abuse imagery is one of those unique cases in which it is illegal everywhere, and so you might argue that the law already covers these sorts of harms. So I think this is indicative of something going on. Now we come to 2015, and we've had the recent platform regulation, and there's some overlap with a previous speaker's conversation here, a previous speaker's presentation. But in the platform regulation consultation, there's some interesting language. Here you see online platforms are playing an ever more central role in social and economic life. So here we see the argument from size creeping in. Platforms can control access to online markets, can exercise significant influence over how various players in the market are remunerated. Argument from size, too much leverage. And then finally, as the amount of digital content grows on the internet, current arrangements are likely to be increasingly tested. So this is the argument from need. The harms are growing, and we need to do something about it. So one thing I wanted to point out in the first bit is that the list of services that they mentioned, search engines, social media, e-commerce platforms, app stores, price comparison websites, are not only multifarious in themselves, but many of them include what were previously called in the e-commerce directive itself information society services. So this is information society services plus. And we might ask what exactly binds them. So let's talk a little bit about whether there are actual harms. Before going into that, I might say I must give the caveat that analyzing consultation documents comes with its own dangers, of course, because these are, in addition to legal consultations or legislative consultations, political documents. But I think my proposition here is that there's something interesting in looking at the way that the tide is going. But so the question that I want to ask is, one, does the data actually bear out that there is a growing problem that needs attending to? And two, is the internet different somehow than the other spheres in which we operate? That is to say, do we need internet-specific child safety laws, or do we need child safety laws? And do we have child safety laws? Same for terror, revenge pornography, and so on. One point perhaps of interest is that this is not limited to the EU, of course. There are several US states that have passed revenge porn laws in light of the kind of global moral panic about what's going on the internet. And then finally, on that point, it seems to me that the e-commerce directive proposes a version of the world in which we do not need internet-specific laws, because it is a layer atop other legislation, right? I mean, it requires notice. It requires, for liability to occur on the part of the intermediary or to be imposed on an intermediary, they have to have actual knowledge of some illegality, some pre-existing illegality, harm, or infringement, which is already codified in law. So let's look at the facts. Now, if you look at copyright, it's clear that things have skyrocketed. This is public data, which you can find online. In the last month, 51.5 roughly million URLs have been requested to be removed. I think Google removes about 97% of them. The other 3% are either flawed, incomplete, or incorrect notices. But so the vast majority of these requests would have been complied with, 51 million, compared to 2011, when for the entire year of 2011, there were 3.5 million URLs removed. So we do see an exponential increase. Now, if you compare that, however, and this needs a little explaining, is that this blue line represents the growth in copyright takedowns. And this orange line represents all other requests for takedown. So that includes, and they're classed in the transparency report as government requests, but that includes court orders, orders from law enforcement that are complied with, and so on. So the picture looks much different if you look at requests for takedowns, non-copyright, which I think is quite interesting. So let me just talk about a few points in light of this. In light of what's happening, that I think are worth keeping in mind.
Could you go back to the
Sure.
previous slide? Because the line underneath is interesting. There are almost 100 companies that requested the removal of more URLs than any government.
Yes.
Could you comment on that for a bit?
Could we just postpone the commenting
Sure,
to
right.
the end?
So just to go through quickly some points that I think we ought to keep in mind. One is that the current rules, I would argue, broadly work. If you look at the initial aims of the directive, the 2010 tone of the rhetoric, if the aim is to foster an internal market while respecting fundamental rights by encouraging the growth of internet society services, this seems still to be the case. And there's a lot of evidence about the economic value of the services that are rising on this basis. The second point is that the current balance of liability only sets a floor. That is to say that businesses like Google, but including many others, have done much more than is required of them by the law. To give you two examples from Google, on YouTube, there's a service called Content ID, which allows copyright owners to give thumbnails of their works to YouTube. YouTube will then continuously and automatically scan the service for uploads of that work, and then either block uploads or monetize them or just leave them up depending on the wish of the right holder. In addition, you've seen the copyright transparency report slide previously. Google has built tools to manage hundreds of thousands, tens of thousands in a matter of hours, typically below 6 hours. So the point here is that the current only set a floor rather than an absolute limit. A third point, that I think we need to think of the increase in numbers on the copyright side as not a matter of system failure. It is true to say that copyright infringement notices have increased, but at the same time, so have the number of legitimate services available to users and revenue being driven by those digital services. And this may, in fact, be how these rights have to be managed. The fourth point, I think there is still room for clarification for the very intermediaries because the case law is very divergent. To give you an example, some courts have assigned search engines protection from liability under Article 14 as hosts, saying that they are hosting providers, whereas others have given them the caching defense, saying that they're caching services. I think that there's a sensible argument to say, in fact, that they are mere conduits, given that they are giving links to further sites. But the point overall here is that there is still room for harmonization and clarification. And then the final point I would make is that a one-size-fits-all approach across all forms of harm and illegal content online is blunt, given that, for example, something like child sexual abuse imagery is something that anyone can identify upon seeing it. Whereas identifying what is a legitimate or illegitimate use of a copyrighted work is subject to other considerations, such as the permitted non-licensed uses permitted by exceptions in the Copyright Directive. Thank you.